that the number today is 1,606. 1,606 matters awaiting trial in the High Court. Interestingly enough, in 2011, the number was 350. So we've gone from 350 in 2011, 14 years ago, to 1,606. The DPP will also tell you that a not insignificant number of these matters are 10 and 12 years old. Now that creates another set of challenges because your police officers who worked hard to investigate a matter in 2012, some may have gone on to retire, gone on to other careers. That case gets called, let's say, next month, and you have the burden of recreating in your mind an entire investigation that you did 12 years ago. I cannot remember anything that I did 12 years ago. And even if I had notes, your ability to present evidence based on notes is like me trying to present a speech based on notes, like I'm doing now. The point is, you have stopped being immersed in it. It has become a distant memory. How do you convince a jury of your honesty and of all the elements that you have to present to them with such an old case? Now, we therefore have to put aside the idea that it is universal and decide what is going to be our standard. There's another element that is crept in. Because of the age of the cases, we now have a large number of accused persons bringing constitutional motions against the state, arguing that the inordinate delay has resulted in a breach of their fundamental rights. And they have been winning. They've been winning. They've been getting damages. Now, these things, as Attorney General, I will tell you, my duty is to uphold the law. And whether it means the rights of the accused or the rights of the upstanding citizen, it's all the same to me. Rights are rights. And I would not stand here and suggest that we can deny a person basic constitutional fundamental rights because they are charged with murder or charged with rape or charged with anything else. Your rights are your rights, and they have to be respected. But I must say that I'm sure, will have a galling effect on you that you've worked so hard in an investigation, done all this work, and through absolutely no fault of your own, somebody not only brings a constitutional motion, the case gets stayed so it can never get tried, and on top of that, your taxpayers' dollars got to go to pay them damages and to pay the lawyers' legal fees. You've done all that you could have done, but the system now almost perverts your hard work. The time has come when we have to start that discussion again. I hope that the police service is open to it. I am not making any decision of this sort has to come from cabinet, but I think that there are a number of factors that we have to take into account which will propel us in that direction. Fundamentally though, the idea behind it is that the investigator should not be responsible for the prosecution. The investigator's only job should be to investigate, prepare the case file, and hand it over to somebody else. Your job is done, except for when evidence then has to be given before the court. But I believe that if we make an investment now in expanding our prosecution skill set by having lawyers do prosecutions in the magistrate's court, I think that will go a long way to helping the system to move along more quickly. Our aspiration has to be that we have an efficient and effective criminal justice system to deal with citizens. And the reasons are obvious. If the criminal justice system does not work, if the backlog piles up and persists, then we will begin by eroding public confidence in our justice system. Eroding public confidence. And if the public is not confident in our justice system, they will not be confident they will not have any confidence in police action. They will not have any confidence in the ability of the system to ensure fairness and proper service. And when that happens, it creates an even bigger problem for you because the criminal mind becomes emboldened. And I sincerely believe that we've seen the effect of this in recent years.